Hi, I'm David Ross. I am a trial attorney and personal injury attorney in Pennsylvania. You may be aware that there's been a lot of activity over the last couple of years with development of natural gas from Marcellus Shale. That development has had a significant impact on the legal community and different kinds of legal actions. One area where we've seen a lot of impact is in the area of title to the oil, gas, and mineral rights under the land. In Pennsylvania, the title to the land can be split or divided. It can be, or in other words, that we use is severed. The surface owner may not necessarily own the oil, gas, and mineral rights for the oil, gas, and minerals under the land. Many times, all or part of the oil, gas, and mineral rights have been severed from the surface rights. And in the past few years, there's been a lot of legal activity and actions brought by surface owners in an attempt to quiet title or regain the rights to the oil, gas, and mineral deposits under the land. The problem with that is that in most cases the action is actually frivolous. It's frivolous in that in Pennsylvania it's very hard to make out a case to quiet title against the owners of the oil, gas, and mineral rights. The two most prevalent theories we see advanced are abandonment or something called adverse possession. We start with adverse possession. Adverse possession in Pennsylvania requires that for a period of over 21 years, the surface owner has exercised exclusive control and dominion over the oil, gas, and mineral rights. Well, unfortunately for surface owners, it's not possible to exercise dominion over something under the land. You can walk all over your land as much as you want, but you're not exercising dominion over the oil, gas, and mineral rights under the land. Now, there is an exception to that. If, for instance, the surface owner had engaged in leasing activity and a well was drilled and they were pumping gas or oil out of there for over 21 years, then you would have exercised control. But absent that, it's impossible to establish that you've exercised dominion and control over the oil, gas, or mineral rights for a period in excess of 21 years. And so in most cases, that theory, that legal theory, is frivolous because it's without merit. The other theory that we see advanced in a lot of occasions is something called abandonment. What happens here is the surface owners will allege that because the property has not been developed and no one has drilled for oil, gas, and minerals or extracted the minerals, that those rights have been abandoned. Well, unfortunately for the surface owners, that does not comport with Pennsylvania law. Pennsylvania law requires that you show an explicit or overt act of abandonment. In other words, they send you a note that says, "We abandon," or there's some kind of writing or some overt action where they prove that they've abandoned the rights. Non-development is not sufficient. So in most cases, that theory is meritless. It's frivolous to bring an action based on abandonment for the simple reason that without an overt act, you cannot meet the elements to show abandonment. Well, these are just a few of the ways that Marcellus gas and the significant dollars being pumped into our economy and to landowners based on the finding and exploitation of the Marcellus gas is changing the legal landscape in Pennsylvania. If you have any questions about Marcellus Shale or its impact on you, or if you're either trying to bring a quiet title action or defending against a quiet title action and you have questions, feel free to contact our firm. If you found this video helpful, please subscribe to our video channel or visit us on the web. Our address is www.rossandrosslaw.com. Hope to hear from you soon.